number 39, Himmelstein, McConnell, Gribben, Donoghue, and Joseph versus Matthew Bender and Company. Counsel.
Thank you, Judge, and good afternoon. May it please the Court. My name is James Fishman on behalf of the appellants. We're here today to ask this Court to reverse the First Department's dismissal, or decision that upheld the pre-answer dismissal of the complaint in this action. The case involves some significant issues concerning the ability of individual consumers who are acting as, quote, private attorneys general to enforce the New York Deceptive Practices Act and to seek damages and injunctive relief against businesses that engage in deceptive business practices.
Counsel, can we jump to the end first and talk about the injury alleged here?
Sure.
And are you alleging that there was a price premium on the TAN book due to the purported misrepresentations? And I'll weave into that question also. How do you apply small here?
Absolutely, Judge, and I agree. That's a very important issue here. It was an issue that was addressed by the First Department, not the motion court. I think that price premium is one way to address the injury. It's not the only way. Certainly, somebody who's looking to buy this collection or compilation would not pay what they paid for it if they knew it didn't have everything it was supposed to have, or that they were told it had. So yes, it did cost more. We think the value is zero. Ultimately, I think it's a jury question to determine how much is this book worth, and it's not a summary dismissal issue. On the other hand, the other way to look at it is that the plaintiffs were deprived of the benefit of the bargain, and there's a long history of cases under GBL 349 that say, and we've cited them in our brief, and referenced cases from, I think, 35 other states that have similar statutes.
But would we have to overrule Small to say that you had alleged a cognizable injury here?
No, Judge, we're not asking or believe that Small needs to be overturned. I do, however, believe that Small should be limited to its very unique facts. In Small, it involved a representation that cigarettes were not addictive. The people who bought those cigarettes still got cigarettes. Whether or not they were addictive or not didn't create an injury. They still got the cigarettes, presumably smoked them, and got the benefit of what they paid for. So using Small
But
here,
didn't they argue that they never would have bought the cigarettes if they had known about its addictive qualities and not been misled by in that place it really was the tobacco industry. They sued all of them.
I mean,
and isn't that similar to the argument here?
Not
where
really,
you're basically saying this has zero value, it's worthless to us, which I had thought that means, and therefore I would not have bought it if I had known it's incomplete.
I think there's a world of difference between the knowledge of addictiveness of cigarettes, which is was well known at the time. It didn't require a cigarette maker to lie about it for people to know that cigarettes were addictive.
Yeah, but then that goes to that you could not have possibly been deceived, which is another issue.
On that
we're going to
case,
get to
yes.
in your case.
Well,
and the court,
I'm sorry.
of course, in Small says deception alone is not an injury, so the court must have thought that the argument was that they were deceived.
Well, I think that applying Small to these facts is incorrect, and it would in fact result in an evisceration of the statute, because this is a bait and switch case for a benefit of the bargain. And as I said, and we've cited in our brief, there's a whole history of cases that say that if you believe you're buying X and you end up getting Y, you've been deceived, and that's bait and switch, or you didn't get the benefit of what you thought you were buying. And the respondent relies heavily, and so did the First Department, on the Second Department case called Rice against Penguin, In that case, the plaintiffs claimed they were deceived because they didn't realize that this book that they were buying wasn't 100% written by a famous author. But if you look at Rice, it says very clearly in the second part of the decision that the fact that that author didn't fully write the book appeared on the copyright page of the book. So if you're standing in a bookstore and you're flipping through the book and you see that, there's no deception. They didn't hide it like they did here. This is a hiding. They hid these errors and these omissions, and they hid their disclaimer. They put their disclaimer on the backside of a purchase order that you don't even get with the book, instead of putting it on the inside cover where people would actually see it. And the purpose of that, and this goes to both deception and the conspicuousness of the warranty, of the disclaimer, that you can't hide a disclaimer that goes to the very heart of the purchase. And that's a UCC principle that this court upheld in the Wilson case in 1968, that's cited in our brief.
Our First Department has a string of cases that address the GBL and seem to have a specific definition of consumer.
Yes.
Someone dealing with personal household goods. How does your claim fit within that First Department definition?
Well, the First Department definition is wrong.
So you're saying we should overturn that line of cases?
Absolutely. It has no place in New York jurisprudence.
And why is that?
Well, first you have to look at the statute.
I'm sorry?
You have to look at the statute, first of all. The text says nothing about personal, family, or household like other sections of the GBL.
The text it doesn't use the word consumer, does it?
It uses the word person.
I see.
It says
So it does
any
not,
person.
so to be clear, it does not use the word consumer.
Exactly. I mean, I believe
How about the legislative history?
the legislative history is also in line with that, as the Attorney General's amicus brief points out. In fact, I can say, from firsthand knowledge, in 1980, I was a newly minted Deputy Assistant Attorney General in the Consumer Fraud Bureau, and I helped write the memo that ended up in the private right of action being adopted for the Attorney General. So I know that the point of the memo was to give all persons the right to bring this as a private Attorney General and not limit it to simply personal, family, or household. We know how to put personal, family, or household, or the legislature did, in other statutes when they wanted to, but clearly they had two chances to do it and they didn't. They could have done it in 1970 when they first enacted the statute, or in 1980 when they amended it to add the private right of action.
When you say
Given
we,
our recent decision in Plavin,
Yes.
how at all does that affect your view of this particular element?
Well, I
of
think
the claim?
Plavin supports our consumer-oriented claim. Plavin involves 600,000 New York City employees who
But
were...
we did say they're repeating,
I'm sorry?
well, you did say they're repeating from other cases that you've got to show it's consumer-oriented,
Well,
correct?
you still have to show it's consumer-oriented,
So
no question.
consumer-oriented is still in play. I
Absolutely.
understand you're arguing for a different definition.
Yeah.
So where would your definition have the limitations that Plavin and other decisions
Well,
from this court have set up?
I think all you have to do is eliminate the personal, family, or household layer that the First Department created out of thin air. In the Cruz case, they analogized it to two other sections of the GBL that did use that definition and had no legislative support, no legislative history support, no case law support. They just came up with it. And then it's been used repeatedly now in the First Department, both at the appellate division level as well as in the lower courts in the First Department, to dismiss cases that otherwise meet what this court has said is consumer-oriented conduct. It has to be, affect the public at large. It can't be a one-shot transaction. Everybody agrees with that. And it has to involve something involving the public interest so that when you act as a private attorney general,
So your light has gone off. If the chief judge will permit me, if you could quickly address, yes, Chief Judge?
Certainly.
do you want me to,
The last element.
I'm sorry, I
The
didn't hear,
last, if you could quickly address the last element of the claim,
the last element of,
the claim under the 349.
well, it's consumer-oriented, that it's deceptive, and it causes injury. Those are the elements. And
Materially deceptive, okay, so how does that fit here?
well, I don't think the deception part changes at all. In fact, the appellate division agreed in Cruz that it met all the elements except for personal
Well, in
offense.
this case, that element has not been addressed by either court below, correct?
The deception element?
Materiality, yes.
Well, I don't think there's a dispute because it's a 3211 posture. So for the purposes of this proceeding, the respondent doesn't dispute that they didn't provide what the plaintiffs claimed they thought they were getting. So, I think that the deception claim hasn't been thrown out. Certainly, the appellate division didn't say we don't have a deception claim. But overruling Cruz, I think, is something that has been something that's needed to be done a long time. As Your Honor addressed in the Collazo case last year, the same with the Iguaza case regarding landlord-tenant matters. The First Department has also restricted 349 in landlord-tenant cases, and Your Honor was very critical of that in your dissent in Collazo last year.
Judge,
Yes.
could I just, I'm
Judge
sorry,
Fagan.
just, if it's okay, just one point. One of the arguments of the defendant is one of their stronger arguments is the reliance and causation arguments that they make. And am I correct saying that you respond to that causation is established by the annual updates implying that the law is up to date in the TAN book?
I'm sorry, you're asking...
One of the strongest points I thought in the defendant's argument, or let's say, I think it's an arguable point, there's clearly two sides to the reliance/causation arguments that they make as to whether or not you've properly pled something's materially misleading. Am I correct in saying that your response to that is that the annual update that's claimed to be done to the TAN book is the basis of your causation argument that the book isn't kept up to date in the law?
Well, they claim that it is. There is a page in the record, which is the table of contents, which says in the 2016 edition, 2015 updates. So they represent in the book itself that it's updated. We found every one of these tabs shows an omission or a incorrect publication of a law that had been repealed. All of these items are listed in our complaint. The 2017 book, published 5 months after the suit, all of those errors were corrected. And
Well,
some
you
of these
pay-
go back to 2005.
Counselor, on the 2017, just to clarify, the plaintiffs purchased that book or paid for that
Yes.
book after they received it 5 months late or so, right?
Exactly.
Okay. So,
And-
okay.
And they did so because it's inconceivable that after being sued for those 37 errors, that they would then 5 months later turn around and publish the book without those errors corrected. I assume, and I think most purchasers would assume, that they went through the book with a fine-tooth comb to make sure that not only were those errors corrected, but the other 1,000 pages were error-free as well. Because imagine if we then found other errors in a different portion of the book after being sued for this section of the book. So yes, I think it was perfectly reasonable to buy the book. It's just that they didn't get a full year's use of it. They got,
But what I'm saying is that they knew when they received it that they weren't going to get a full year's use of it.
that's true.
And they
That's
had
true.
the option then to either send it back
Well-
or not pay for it.
Well,
or
because
pay for it.
the book serves a very important purpose, and our plaintiffs said that in their affidavits. This is
But
a,
wouldn't that indicate that then the plaintiffs found that there was some value to it?
well, if the 17 book certainly had value because it's believed to be complete, and it's a one-volume, handy, softcover book you can take with you to court. You can keep it, at home, whatever. So yes, the 17 book had value, just not the 12 months of value that you would have gotten every other year. So you only got 7 months of value, but at the same time, they continued to sell the 16 book. I bought it online in August of 17. And so, that just goes to the overall sense here of a company that really doesn't care what they're selling to the public. And I think that the state really has an interest in saying to businesses that that's just not how we do business in New York.
Thank you, counsel.
Thank you, Judge.
Counsel?
Good afternoon, Your Honors. For Respondent Matthew Bender, Anthony Dreyer, joined with my colleague Jordan Fearman. Your Honors, as Judge Stein put it, I will jump to the end very quickly, but there are 2 preliminary points I would like to make. The first is that Matthew Bender has never once disputed that the 2016 TAM book, or at least Part 3, was not current or accurate at the time, and it's not something we were happy about, it's not something we were proud of. But as every judge who's looked at this case, all 5 judges of the Appellate Division and Justice Ramos have recognized, plaintiffs must plead more than a mistake. They must plead each and every element and facts to support each and every element of the claims that they brought. And that's particularly acute with the 349 claim, and that brings me to my second preliminary point. Separate and apart from the injury issue, there are 3 other independent defects in the pleadings that warrant dismissal. The first is that the terms of service that they agree are binding, they try to bring a belated breach of contract claim under those same terms and conditions, expressly negate the alleged deceptive practice. The second is that, respectfully, this is not a consumer-oriented good. As they acknowledge, this is a book of laws, a book of codes, marketed to lawyers and other legal professionals.
Well, you market it on Amazon, right, and your own website, and, did you treat these plaintiffs differently from any other customers that might come across it and decide to buy it?
Well, I think with respect to the marketing on Amazon question, Judge Stein, I think any bookseller these days has to market on Amazon. There are very few bookstores. I don't think this court has ever held that the marketing channel in and of itself is the test for whether something is consumer-oriented. There's a question as to who the target audience is and what the practice is. And I think this is not consumer-oriented under either the first or third department's definition, which tried to ascribe words to consumer-oriented, which is, of course, an unquestionable element of a 349 claim.
Well, have we ever said that somebody that uses something for business purposes doesn't qualify as a consumer?
No, and we've not argued that, Judge Stein. There are instances where something that's marketed broadly to consumers and also used by businesses could be consumer-oriented. A laptop, for example. We've never disputed that.
Well, I guess my question is a little different. Can't a person who utilizes something in their business be considered a consumer? If, as some argue, the statute was intended to be broad in that way.
Well, respectfully, Your Honor, I think that's what the Attorney General is arguing, and that's what the legislature is considering, to broaden 349 to not just be focused on pure consumers.
Well, the pending legislation I don't think is really helpful, because it may be that they're seeing that there's this other case law going on and they don't agree with it and they just want to clarify it, not that they didn't mean it to be that way in the first place.
I understand, Your Honor, but generally, the generally accepted definition of consumer is not someone who purchases for their business. It's a product that's marketed for, I do believe the first and third department tried to ascribe a rational meaning, a common sense definition to what constitutes consumer, somebody who buys for themselves, their family, or for other personal use, their household, not for business.
Well, you
And
do
so-
have one plaintiff who said that he bought it for his personal use, right?
Well-
As a tenant. I mean, it is hard to see this argument that you're making, that a book that in part has legal materials that tenants as well as property owners might have an interest in isn't something broader than sort of a small group or bounded by a unique contract, which is what our case law has said. That's not consumer-oriented. It's hard to see that in this case.
Well, again, respectfully, Judge Rivera, I don't think the test is whether a consumer might buy it or a consumer might find it interesting. And this is not an ordinary consumer. This is somebody who's a tenant advocate. They have a TV show advocating for tenants' purposes.
Well, here's the problem with the argument on Judge Stein's point and Judge Rivera's point. I see the Attorney General's amicus brief as having three main points. The first is that nothing in the text limits 349 to purchases of personal, family, or household goods. There's nothing in there that says that. The second point, and it's indisputable in my mind, second point is they never even use the word consumer in the text of the statute. Third point is the GBL statutes, or excuse me, other GBL statutes do expressly define consumer goods. And the way I understand that argument is the legislature knew how to do that if they wanted to, and that's not what was being done here. It appears to have been an attempt to create a much broader right, and we would have to have some basis to define classes of consumers, and it's hard for me to find that in the text.
Well, Your Honor, I think the article that 349 is under is unquestionably a consumer protection statute. We've set that forth in our papers, and this court has
So then we come
recognized-
down to classes of consumers, is that correct?
Forgive me, Your Honor?
Classes, different classes of consumers. The way I understand your argument is that someone who's a class of consumer that's using a particular good for personal, household goods, or family purposes, that class of consumer is covered in the first department, but the statute doesn't say that.
Well, I don't equate purchasers with consumers. I don't think all purchasers are consumers. That's the argument.
Okay, let's stay with my question, though. My question is the class of consumers that was created by the first department doesn't seem to be in the statute.
Correct. What I believe the first and third department were doing, Your Honor, was to try and give a common sense definition to the word consumer.
I see.
Let me briefly touch on causation so I can come to the end, and it's taken me a bit longer to get there. I apologize.
Oh, trust me. It
The
always
second
is.
independent or third independent defect, aside from injury, is that plaintiffs have not, as they must, plead facts to establish causation. They have to
I'm
allege not
sorry,
just-
I'm having a little hard time hearing you just because of the mask.
Forgive me,
you know?
Your Honor,
Yeah.
sure. They have not pled facts to establish a necessary element that the alleged deceptive practice caused them injury. Recall, the alleged injury, I'll come to price premium in a minute, I promise. The alleged injury is that they wouldn't have purchased the TAM book at all had they known, and that the alleged deceptive statements were the website statements and the statements in the book. So they have to show a causal link between the two. Two of the three plaintiffs never even referenced that they saw the website or the book. And the third plaintiff, Mr. Himmelstein, does not draw the causal link at all. His main basis for his belief is his assumption, his understanding.
They don't have to plead reliance, right?
That's correct, Your Honor. And I'm not saying reliance, but they do have to plead causation.
Well, but, you know, some of what they're claiming are the misrepresentations are on the cover of the book, or it's in the table of contents, where some areas, for example, say selected provisions or portions, and others don't. The section at issue here. So can't we infer that they saw it? Even, I mean, I don't necessarily agree with you that they didn't say that they saw it, but let's assume they didn't. You know, can't we infer from those facts that they would have seen it if they looked at the book?
Well, I think the place that you're referencing is the overview page, and the alleged deceptive practice is solely the use of the word "the," where they use selected elsewhere. Let's assume for a moment that's a deceptive practice. We have addressed that in our brief. But I think they do have to allege some causal nexus. Otherwise, there's a misstatement in the book, they allege, and they bought the book. There's no causal nexus.
So you're arguing then that the plaintiff must plead that they saw a misleading statement. Is that what you're saying?
If the injury is, as alleged here, that we
All
bought
right,
the book.
Let me take a step back, just so I understand this.
Sure.
And so if that's the case, follow up with Judge Stein's point, which is a good one, well, then wouldn't it be sufficient to just simply say, I bought a book that I was told was annually updated, and I find that it was not annually updated, and that should be sufficient? They don't need to go through and earmark, you know, the 700 different misleading statements.
Well, I think it's one thing, Judge Fahey, to say it's annually updated, and another to say, I believed, contrary to the terms of service, that it was current and error-free.
Well, let me put it another way. Do you dispute that there were misleading statements in the TAN book?
We do. I think their whole basis for
You're saying there were no misleading statements?
Their whole basis for alleging there was a misleading statement was the use of the word "the" in
No,
referring
that's
to
not my
Part
question to
3.
you. Do you dispute factually that there were misleading statements in the TAN book?
We have, Your Honor. We have, Your
Okay.
Honor.
All right.
And so...
Well, then that's you're certainly, you have a right to do that, but the other side of that is, in terms of causation, you have to look at a reasonable consequence of a consumer's action, and if they're told that the book is updated to comply with the law, it's a kind of a question of fact for someone other than summary judgment.
Respectfully, Your Honor, that is not the pleadings, and I think there's been an issue throughout this case of the plaintiff's theory shifting like the sands, and I urge the court to go back to what was alleged, and that's particularly acute with injury, and I see
Okay, we
I've
will.
run out of time. If I could just briefly address the injury issue.
Please, sir.
Thank you, Your Honor. There should be no doubt that Lorillard does apply to this case. The only injury they've ever alleged throughout this entire case, up until they got here in the reply brief, was that they wouldn't have purchased the book had they known the true facts. That's exactly what this court held in Lorillard.
But are you saying then that, that this statute would never permit recovery for someone saying that they didn't get what they paid for?
No, but respectfully, Your Honor, I think they have to say more. This court and other courts have recognized that if plaintiffs plead facts.
Well, what more do they have to show?
Well, first of all, they never pled that in this case. That's not the pleading. The alleged injury, all the way up until the reply brief, was not price premium. But that is the case in every 349 case, Your Honor. In every single case, the plaintiff says, I didn't get the non-addictive cigarettes I thought I got. I didn't get the smart water that I thought I was going to get. I didn't get, I mean, that's deception. That's not injury. And that's what this court unanimously recognized in Lorillard.
The difficulty, I think, in that, in drawing a parallel, is that in Lorillard there's an odd procedural history where there had been claims about addiction, and class was not certified because those were deemed to be more individual than class-wide issues. And the court then said the nicotine addiction issues are out of the case, and the plaintiffs proceeded as individuals and there was no addiction theory. So there's a way to look at Lorillard as not about injury but about causation. That is, people buy cigarettes because they look cool, they buy them because they like the taste of them, they buy them for whatever reason they buy them. And if the addiction issue is out of the case, then there's a disconnect because they're buying the cigarettes for a purpose, tastes good, looks cool, whatever it is, and they got that. Your case is different because they're buying the book for its contents, and its contents is not what it's supposed to be.
But respectfully, Your Honor, I think this is why Lorillard was rightly decided and why it shows why this case lacks injury. All three plaintiffs used this book for well over a year. The Himmelstein law firm is not just one lawyer, it's 10 lawyers. They used it for 1 year without issue, without injury, without incident. And so this allegation that it was worthless is not only unsupported, it's belied by the facts that are in the record. And they continue to buy it, knowing that we're not representing that it's current or complete or accurate. So respectfully, this allegation that it is worth nothing is undercut by the facts. And if all a plaintiff had to allege in a 349 case is consumer-oriented and I was deceived and I wouldn't have purchased it, then injury is out, and 349 effectively is a strict liability statute.
But let me just ask you about your answer then. So if they had not purchased the book, that is, they discovered their errors and they stopped, does Lorillard have any application here?
I don't think that matters. It's just one additional fact, Judge Wilson, that shows why the evidence in this record belies their assertion that the book is worthless. They used it for 1 year without issue, without injury, or any incident. So that was the point. And, respectfully, if Lorillard is done away with, because again, the injury in Lorillard was we would not have purchased the cigarettes had we known the true facts. Just like in Rice, we would not have purchased this book had we known the true facts. That is deception. That is the consumer saying, I wasn't entitled to make a free and informed purchase. And this court unanimously recognized in Lorillard that may satisfy the deception prong, but there has to be a separate injury. And there simply was not a separate injury here alleged. Thank you, Your Honor.
Counsel. Counsel, do you care to have 2 minutes of rebuttal time?
Very briefly, Judge. First of all, counsel just said something that is completely outside of the record and inaccurate as well when he said that Lorillard that Bender disclaimed that the book was complete. there is no disclaimer of completeness. They disclaimed currency, accuracy, and
Well,
reliability.
but wasn't that based on the lack of completeness?
Well,
in-
they
in all
didn't
fairness.
say the book, we don't...
But that's what the claim is based on, right?
Well, but completeness is very important in this case
Well, if
because,
it's not complete, it's not accurate, right?
well, sure,
And-
but it could be...
And if it's not complete, it's not current.
Well, except they argued before the motion court and the appellate division that the book, that they specifically disclaimed completeness, and specific disclaimers are different than general disclaimers. They never disclaimed completeness at all. And to not include amendments from the city council from 2005 for 11 years makes it hardly complete. And those are not just,
Well,
minor amendments.
let me ask you this. If what the disclaimer said was, we do not warrant that the book has everything, every word that is in the law,
Okay.
is that the equivalent of completeness?
Is that equivalent
The
to...
equivalent of completeness?
I think that would be a de minimis claim that would not be actionable, Judge. We're not here because...
So then the point of that question is it not possible to read the three words that they use as the functional equivalent of completeness?
Maybe that's a
They don't have
fact
to use
issue.
that word specifically.
Maybe that's a fact issue, Judge. I'm not sure it's a legal issue, because certainly to say in the table of contents, we're only putting in selected portions of these laws, but this law, this section, it's the laws, that suggests completeness, and it clearly was not. And we wouldn't be here if they had missed a few semicolons or commas. I mean, they didn't publish the disabled rent increase exemption for 11 years. That affects every disabled low-income New York rent-regulated tenant, of which there are tens of thousands, and they just didn't publish it.
Let me ask you this. Is he correct in the way he has described your assertions in the complaint regarding the injury?
I think there's several, no, I don't think he's correct, and here's why. First of all, this is a class action. So there are probably thousands of purported class members out there who we allege in our complaint that these are common injury, common damages. Now, we've asked in our...
Yeah, but the class representatives
Right.
have to meet all of the elements.
Right.
Again,
Exactly.
I just want to be clear if you disagree in the way he has characterized your assertion of the injury, or do you want to address that?
What we've said in the complaint, what we've said throughout this litigation is that we're going to seek, if we get the opportunity to, we're going to seek to recover the purchase price. But ultimately, what the book is worth, I believe, is a fact question. And a jury should decide, is it worth 0 or is it worth, 50% or 75, whatever. But certainly we're going to ask for the purchase price to start.
Okay.
And
Can you address his argument that none of the purported class representatives ever said that they actually did indeed read these alleged misstatements?
well, it's actually not correct. Mr. Himmelstein said it. In fact, the appellate division recognized that he did. And Mr. McKee said it as well in his affidavit. But also, he mentioned...
Well, what did they say?
They said we saw or we relied on the statement selected provisions versus the provision, the law. Mr. Himmelstein
Well,
says...
did they merely describe it or say, before I purchased it, I was aware of these representations?
Well, first of all, you have to, also in the context, they didn't just buy this book once. They bought it year after year.
Okay.
And so, do we have to show that they saw it in year 1, in year 5, in year 10? They kept buying the book because of that reliance, that belief that these things were accurate.
Yeah, but
Mr. McKee-
what did they assert the basis for their understanding?
Yes. Mr. McKee says at page 231, in buying the book year after year, it's long been my understanding and reasonable assumption that the Tan Book is a useful source for the entire collection of the rent regulation laws. And then he says, for many years it's been my understanding that the Tan Book contains the laws in their entirety, while the book only contains, quote, selected sections or excerpts.
But I guess the question is that because someone told him it's complete, or because he looked at these statements and relied on the alleged representations by?
They can certainly ask him that at
Defendant.
deposition, Your Honor. But he says very clearly in his affidavit, I relied on what it says in the book. And he had to have seen it to say that. So that certainly meets the standard.
Thank you, counsel.
Thank you, Judge.